Good morning, Your Honor. John Holman from the Santa Cruz County Attorney's Office. On behalf of all named defendants, with me is Charlene from the same office.
Would you wish to do an opening?
Yes, Your Honor. Your Honor, the defendants also have a couple of preliminary matters to attend to as well.
Yes, sir.
Your Honor, the defendants would like to renew the motion to continue today's proceedings. And the motion that was filed yesterday was just a very short motion. If I could briefly expand on that for the court's benefit. As the court is aware, this matter is proceeding as an order to show cause from a special action, a statutory special action. And special actions, although they have an expedited procedure, in this type of scenario, there's no pending litigation with a jury waiting for the ruling to make a verdict. So the argument that I'm making, Your Honor, is although this type of special action requires an expedited procedure, it doesn't require that the matter be resolved overnight. That the parties have not exchanged any type of discovery. I don't know. There's no witness lists that have been exchanged. Basically, the defendants at this point are going in today's hearing entirely blind. On top of that, Your Honor, this is a matter of statewide importance. As the court knows, there's 15 counties in the state. 13 are the smaller counties, of which we are one. The Secretary of State has expressed an extreme interest in the outcome of this and is contemplating whether or not it can specifically intervene. It's my understanding that the Attorney General's office attempted to appear by telephone this morning, but was denied that request. And so, Your Honor, that's another reason I believe that this matter should be continued so that we can more fully address the issues. As a matter of equity and fairness, Your Honor, I don't know what type of witnesses we're going to hear from today, factual witnesses. There may be people proffered as expert witnesses. At this point, the defendants don't have any type of expert testimony because we haven't had time to secure any type of expert. We were served with this complaint in the middle of last week, and based on that timeline alone, Your Honor, any evidence that the court will hear today is going to be entirely lopsided. We're dealing with a matter of extreme importance. The integrity of the election process as a result of this public records request being made for materials related to the computer software and these elections. We're not going to be able to resolve this issue before this imminent general election that's coming up. So it's the defendant's position that any action that is taken without proper reflection is going to be of detriment to the county, potentially, and also by implication and by appearance. That there, frankly stated, Your Honor, there is no fire, that this needs to be resolved today. It's my understanding that the court didn't have the availability on the dates that were stipulated to by the parties of October 6th, 7th in the afternoon, or the 8th. And I know that the court did make other efforts to accommodate additional dates, and it's the defendant's position that additional time is necessary in order to fully develop this issue, in order to fully develop the defense that we intend to present, Your Honor, to this request. And again, I'll just reiterate the point that a special action, although it is an expedited matter, it's not to be addressed overnight. In addition, Your Honor, one of the main defendants, the principal defendant, I'll go on record as saying, is the Santa Cruz County Board of Supervisors. That Board of Supervisors is a political body that meets every other week. We haven't had any type of meeting. The Board of Supervisors haven't had a meeting in between date of service and today's hearing. And based on that, Your Honor, we have to comply with open meeting laws. And so any settlement offer that has been proposed or is contemplated, we simply don't have sufficient time to address that sufficiently to be able to respond to potentially resolve this matter short of testimonial litigation. So again, based on that, Your Honor, the defendant would ask I would renew its motion to continue today's proceedings.
Before I give you a chance to respond, let's make sure we understand there is nothing before this court to address the integrity of the election process. This is a simple records request. That's all it will be. And I will not allow testimony that goes beyond that specific interest. Second of all, the county attorney's office has been on notice since July 28th that plaintiffs intended to bring a special action, and why, and under what statutes, and the purpose of which. The Board of Supervisors members have been on notice since August 18th intent to file special action, the circumstances, and what the plaintiffs would be seeking. So I take issue with the we're not prepared because we got served last week, and the lack of specificity. You haven't told me one thing you need to do.
Your Honor, the defendants would like to exchange a list of witnesses with the plaintiffs, a list of exhibits. The defendants would like to retain an expert witness and has been trying to actively engage in pursuing somebody qualified to address this issue, frankly, Your Honor. And that's, I'll speak to that later in my opening statement and in other motion that I would like to bring before the court. But this is a technical issue, Your Honor, and it's not something that a layperson can address very easily. And despite diligent efforts to secure an individual as an expert, the county has been able to do so. Been unable to do so far, Your Honor.
Your Honor, we have offered to the county a swap of lists of witnesses and their proposed testimony on Friday via call, again on Monday renewed via email, and the county declined that. As you stated, it's no secret that this lawsuit was going to be brought, and before I filed the lawsuit, I reached out to the county's attorney's office and asked them if they'd be willing to waive service of process so that we could get this expedited. They declined that request. As you know, it takes time for the process server to track down each individual member of the Board of Supervisors and serve them, and that is why I made that offer to them, so they would be able to prepare. We need to have this resolved by the time early ballots go out because, you know, the data could be variously useful depending on that. So, you know, it could be useful for the election in one way or another. Again, that's not the issue here today, but that's why the records are needed. And quite frankly, for an order to show cause, the standard is 24 to 48 hours. So the county has had a lot more time than a typical OTC already, or OSC already. And finally, I would suggest if the county has difficulty retaining an expert in that time, we managed to do it. We're a little office. It's me and my assistant, and that's it in Phoenix. And we somehow managed to do it in a very short time frame. I would posit that with all the resources of the county, they should have been able to do it as well. That's all.
Mr. Holman?
Your Honor, just perhaps that was a Freudian slip, but counsel said that the data would be, I believe he said variously useful.
Metadata, Your Honor, I apologize.
Either way, Your Honor, the metadata or data would be variously useful. The defendant's concern is it would be nefariously useful, Your Honor. We simply don't know. And that's the fact that this is a technical issue. The fact that the Board of Supervisors was aware of this grumbling, that there was a written public notice request made, is one thing, Your Honor. As the court is aware, talk is cheap. Claiming that you're going to file a special action is entirely different than actually filing the special action. The special action was filed, I believe, on September 8th. The defendants weren't served until last Wednesday, which was the 17th. So there was a 9-day delay. The fact that I don't even think the Board of Supervisors were served with that, with the complaint, Your Honor. The people that were served were the county recorder and the clerk of the Board of Supervisors. We don't have to track down parties at their homes. We had to just simply bring those documents, meaning the plaintiff had to bring those documents to the county offices during business hours. These aren't people that are evading or hiding for service. There was a 9-day delay that had absolutely nothing to do with the defendants. Right now, we're on, and the fact that counsel was brought up a settlement offer.
There's a settlement offer on the table, Your Honor.
There was a settlement offer extended, and it was extended via email on Friday when the county attorney's office isn't working, and it was indicated that was renewed on Monday. That's what counsel just represented to the court. Well, there's not a Board of Supervisors doesn't meet until October 1st. It was an impossibility, a logistical impossibility for the defendants to actually be advised by their counsel of that open settlement offer until that October 1st meeting that they have, Your Honor. So that's, we're dealing with, again, grumblings that was cheap talk until that complaint was actually filed and until that complaint was actually served. And Your Honor, based on that, the defendants have only been on notice of this lawsuit for, I guess, 4 business days, 3 of which, or 1 of which isn't even a real business day because the counsel for the defendants wasn't working. So we're basically dealing with a week, weekend inclusive, that the defendants have been aware of this lawsuit. And again, on one hand, they're arguing that this has nothing to do with the election. On the other hand, they're saying, hey, you know what, we need to know the results before the upcoming election.
Objection, Your Honor, we have not asked for the results.
Well, pardon me, they need the public records requests, they need the results of their request prior to the election. Well, why? Those are apples and oranges, Your Honor. And to release that information without, or to make a hasty ruling on whether or not those metadata or data should be released 3-6 weeks before an upcoming general election is extremely scary prospect to the defendants. And that's the reason that we need to exercise caution, Your Honor, and that's the reason why the defendant should be allowed to exchange witness lists, a list of exhibits with the plaintiff, that we should be able to should be allowed to retain an expert witness to identify the technical issues that we're not going to be able to address today.
Your Honor, they're correct. The timing of this is screwy, and it's screwy because those records should have been released per Arizona law the day of the request. They should be open to public inspection at all times during normal business hours. The fact that it's gone on this long is something difficult, and I would also posit that if the defendant is having difficulty finding an expert, it may be because no expert will testify in the way that they wish, because this is a computer matter, and as we all know, computers are not subject to passions. Computers are what they are. So.
Motion continues tonight. You said you had another motion?
Yes, Your Honor. Pursuant to Arizona Civil Rule 53A and B, the defendants would move at this time for the appointment of a master to address the technical issues and come up with the specific findings of fact that the court will be necessary for the court to determine. The principal issue, Your Honor, is whether or not the requests that were made are actually even public records. At this point, in argument up to this point, the state hasn't even addressed that issue, but or the defendants haven't necessarily addressed that issue, but there is a question, an open question of fact of whether or not the records that were requested even qualify as public records subject to a public records request, Your Honor. And given that, Your Honor, given the fact that this matter will proceed without the defendant's ability to procure an expert, the defendants would ask for the appointment of a master, again pursuant to Rule 53A and B of the Arizona Rules of Civil Procedure.
Your Honor, the defendants claim that this is a difficult issue as to whether these records are public record. It's metadata as public record. It's really not a difficult issue. Lake versus City of Phoenix, the Arizona Supreme Court came out and pretty much blatantly said these sorts of records, metadata is public record. And then again in Democratic Party versus Pima County Board of Supervisors, the court again ruled that.
Objection, Your Honor. We're citing unpublished opinions at this point.
Lake versus City of Phoenix is published.
What's the first name versus City of Phoenix?
Lake, like a body of water.
Anything else before we proceed?
Yes, Your Honor, may I approach?
Yes.
Your Honor, I'll be filing an open court a motion to dismiss the improperly pled parties to this lawsuit. That's the original. And I believe that motion speaks for itself, Your Honor. Basically, we only have one real party in interest, or plaintiff in interest, and that would be Plaintiff Breakey. Americans United for Democracy and Integrity and Transparency in Elections is an unincorporated association that inherently lacks capacity to sue. And in my motion, I've cited the case that references that, Your Honor. There is an exception if there's an enabling statute. There is no enabling statute that's been alleged in the complaint, and understandably, pursuant to Rule 9 of the Arizona Rules of Civil Procedure, a plaintiff doesn't need to affirmatively assert capacity unless it's been challenged. And at this point, the defendants are challenging the unincorporated assertion the unincorporated associations capacity to be a part of the lawsuit. Additionally, the defendants have moved to dismiss the the 7 other named natural person plaintiffs who are not plaintiff Breaky. And the reason for that motion, Your Honor, is they are not the real parties of an interest. Simply stated, if the court were to look at the complaint allegation by allegation, and if the defendants were to admit every single one of those allegations, the 7 remaining plaintiffs, other than plaintiff Breaky, didn't do anything. They had no direct contact, with the exception of plaintiff Arellano Oros, who was present when plaintiff Breaky hand-delivered the written public record request, signed only by plaintiff Breaky. And based on that, Your Honor, the other named natural person plaintiffs aren't real parties in interest, and they have no claim upon which relief can be granted. And so based on rules 9A, 17A, and 12B6 of the Arizona Rules of Civil Procedure, the defendants move for those parties to be dismissed.
Your Honor, we have actually no objection to Americans United for Democracy, Integrity, and Transparency in elections being dismissed. That's for the contention that the other parties are not real parties in interest. That's incorrect. Sergio wrote part of the records request along with Mr. John Breaky, and submitted it along with Mr. John Breaky, so he was just as involved in everything as Mr. John Breaky was. The other named plaintiffs had asked AUDITAZ and John Breaky and Sergio to submit this request, so they're real parties in interest insofar as, not everybody's equipped or has the time to manage and shepherd a public records request through the system, so they requested that they do it. That's why they're there, and we can present testimony on that if you would like, Your Honor.
Thank you. Since there's an agreement to dismiss American United for Democracy, Integrity, and Transparency in elections, I'll grant the motion to dismiss in part. I will reserve ruling on the balance of the request. We'll go forward. I'll allow you to present that evidence if you think it's significant. Is there anything else?
One moment, Your Honor.
Yes.
Your Honor, the defense would simply like to make one final record, and that's that we are being forced to proceed with today's order to show cause hearing without counsel having had the opportunity to consult the defendants, the Board of Supervisors, because there hasn't been an opportunity for us to meet and confer. Regarding the specific complaint, Your Honor, that was again served last week.